Hey guys, welcome to the most magical chapter in the history of human justice. Here, the defendant may be the old hen that stole vegetables from your backyard. The defense lawyer is defending the innocence of a group of termites, and the judge is seriously considering whether to issue an arrest warrant for cockroaches. That's right, tonight we are going to talk about the medieval animal trial that makes modern people laugh. A judicial tale that even animal world dare not write like this. Now please imagine that you are sitting in a small town court in France in 1440. The air is filled with a mixed aroma of mold and livestock manure. The wig on the judge's head may be heavier than his IQ, and your fellow jury members are seriously discussing, should we exorcise the mouse before sentencing it? Look, the one tied to the defendant's bench over there is a sow suspected of murdering a baby, and its defense lawyer today was hired at the cost of 3 hens. These cases are not some rural fun, but serious judicial procedures recorded in black and white. From the killer pig sentenced to death by hanging in France in the 15th century, to the eviction order issued by the Swiss court to the termites that gnawed furniture, to the class action filed by the Italian bishop against locusts that destroyed crops, the medieval people proved with strength that when the brain hole meets the dogma, the sparks produced can illuminate the absurd universe of the entire judicial history. The most amazing thing is the missing mouse case in 1522. A group of accused mice collectively missed the trial, and their lawyers applied for an extension on the grounds that the parties were far away and had many natural enemies. And what's even more magical is that the judge actually approved it. This is much more creative than the network delay excuse that some companies are looking for now. So tonight, let's hold mead or the milk tea at hand and watch this judicial farce that has lasted for centuries. Warm reminder, please control your laughter during the viewing process. After all, who knows if your cat will be held accountable by the medieval court for knocking over a vase one day. Let's go back to the French village of Fesnay in 1386, where a trial of the century was taking place that would make modern jurists collapse collectively. Standing in the dock was not a vicious criminal, but a sow with "none of my business" written all over her face. The poor animal was charged with intentional homicide for biting a baby's face and arm, and was about to face the full service of the medieval judicial system. The rigorous preparations for this trial were enough to make today's judicial organs ashamed. The court not only equipped the sow with a defense lawyer, this unfortunate legal worker might have been handling land disputes for a nobleman the day before, but today he had to study the constituent elements of pig crime. What's more exaggerated is that the court also seriously collected eyewitness testimony and recorded the incident in detail, and almost gave the pig a mental evaluation. The court scene was solemn and dignified. The judges wore wigs and held gavels, seriously discussing the criminal responsibility of a beast. The scene was like Animal Farm meets 12 Angry Men. After a fair and rigorous trial procedure, the court finally sentenced the sow to be hanged. Do you think that's the end? The performance art of the medieval people has just begun. Before the execution, they put men's clothes and gloves on the pig, as if this would make this judicial murder more civilized. What's more black humor is that even the piglets of the sow were executed as accomplices, which perfectly interprets what it means to rather kill 100 by mistake than let one go. All the details of this farce were carefully recorded in the official archives. Even the remuneration for the executioner and the cost of buying ropes were clearly recorded in the municipal account books, showing a ridiculous bureaucratic spirit. This kind of absurd drama was not an isolated case in medieval Europe, but a common judicial phenomenon. In the concept at that time, animal crimes, like human crimes, were a violation of the sacred order created by God, and formal legal procedures must be used to set things right. So you will see, in 1457, another group of pigs was tried in Savigny for similar crimes. In 1474, when the Swiss court tried a group of woodworms that gnawed churchwood products, they even appointed public lawyers for them. The most amazing was the rat lawsuit in France in 1522. When the accused mice collectively missed the trial, their defense lawyers actually applied for an extension on the grounds of the long journey and many natural enemies, and the judge actually approved it. Behind these cases is the unique worldview of the medieval people. In their eyes, the whole world is an organic whole created by God, and animals, like humans, must be bound by divine laws. This concept leads to a strange paradox. On the one hand, They admit that animals have no rational thinking, but on the other hand, they insist on convicting and sentencing them. Just like modern people know that the cat master at home cannot understand human language, but they will still reason with it, but the medieval people upgraded this behavior to a judicial procedure. From a modern perspective, these trials are simply performance art. Imagine if today's judges sentenced a biting chihuahua to intentional injury, or issued a subpoena to a stray cat that stole takeout. It would probably be made into an emoticon package and spread wildly by netizens. But in that era when science and rationality had not yet fully awakened, this everything can be judged thinking instead reflected a weird concept of equality, at least in front of God. Both humans and animals are responsible for their own actions, although the way to be responsible is to send the latter to the gallows. So the question is, why would these educated judges and lawyers participate in this farce in a serious manner? The answer may be more ironic than imagined. The medieval judicial system is like a schizophrenic patient. One hand tightly grasps the rigorous procedures of Roman law, while the other hand tightly grasps the spell of superstitious thinking. Their obsession with legal procedures has reached the point of obsession. Even if it is a trial of a flea, they have to go through the entire process of filing a case, collecting evidence, defending, and judging, as if this can prove the superiority of human civilization. This bizarre judicial practice did not gradually disappear until the 18th century. With the rise of the Enlightenment, people finally realized that it was more practical to study how to eliminate cockroaches rather than spend time writing indictments for them. But this period of history leaves us with interesting thoughts. When modern people are arguing about animal rights, medieval people have already pushed this issue to the extreme with their unique ideas. However, their solution was not to set up an animal protection association, but to open a defendants VIP seat for animals. Looking back at these cases today, the most ironic thing is that the animals on trial did not know that they were participating in human legal cosplay. Just like the audience on the live broadcast platform now gives rewards to the anchor, but the anchor thinks it is a system bug and is not on the same channel at all. The medieval people tried their best to find an explanation for animal behavior, but the result only proved one thing. Sometimes humans can do anything absurd to make up for their worldview. From a psychological point of view, this kind of animism trial thinking is actually an alternative struggle of humans against uncontrollable natural forces. When pigs bite people to death, rats steal food, and locusts destroy crops, helpless civilians can at least get some psychological comfort through legal procedures. See, we can even judge animals, which shows that humans are still the masters of this world. This mentality can still be seen today. For example, the practice of some countries suing oil companies for causing climate change is essentially trying to bring natural phenomena into the legal framework of humans. Speaking of the weird lawsuits in modern society, they are almost the same as the medieval animal trials. Someone in the United States sued McDonald's for $1 million because the coffee was too hot, and an old lady in Russia sued the developer of The Witcher 3 because her grandson was addicted to games. Compared with their medieval counterparts, modern judges at least don't have to consider philosophical questions such as whether the coffee cup has the intention to harm or whether the game character abets the crime. It can be seen that although the judicial system has improved, human imagination is always on the road. These animal trials also accidentally contributed to the budding of early animal protection awareness. In some cases, defense lawyers will emphasize that animals are just following instincts, and this view later evolved into the basis of modern animal rights theory. It's funny to say that humans finally realized that they should not be convicted by convicting animals. This cognitive transformation process is full of black humor, just like giving a child a slap before telling him that hitting is wrong. From a broader perspective, the medieval animal trials are actually an interesting stage in the evolution of human cognition. Just like children will hold weddings for dolls, people at that time were also interpreting the world in their own way. It's just that they didn't use toy teacups, but real courts. They didn't get married with dolls, but donkeys and goats accused of crimes. This naive anthropomorphic thinking, in an era when science was not developed, actually constructed a self-consistent worldview. Today, when we laugh at these absurd trials, perhaps we should also think about, will humans hundreds of years later also look at some of our current righteous behaviors in the same light? Just like the judge who dressed the pig to execute him, he must have felt that he was upholding the sacred dignity of justice. Who knows whether humans in the future will regard our attempts to judge AI and prosecute algorithms as performance art in the digital age? In the final analysis, the most valuable legacy of these animal trials may be to remind us that justice in any era has its limitations. The trials that seem absurd today were serious judicial practices at the time. This contrast itself contains profound revelations. The pursuit of fairness and justice by humans is always on the road, and humbly recognizing the limitations of one's own cognition may be the beginning of true wisdom, just like what those medieval judges could never figure out. When they were busy convicting animals, perhaps the animals were also judging the stupidity of humans in their own way. Now let's go back to the unfortunate sow at the beginning. It may not understand until its death that it was just following its instinct to find something to eat, so how could it violate human laws? And those who participated in the trial were also confused. They had clearly strictly followed the procedures, so why was the world still so chaotic? This two-way confusion may be the most profound irony left to us by the medieval animal trials. When humans try to use the rules they invented to constrain the entire natural world, they often make the most absurd jokes. Dear readers, while we are still sighing over the sow that was hanged, let's turn our attention to another incredible group of defendants in the medieval courts: insects. That's right, in those solemn courts, locusts, caterpillars, and weevils were not only frequently summoned to court, but also enjoyed professional legal defense services. This is much more hardcore than modern people hiring lawyers for their pets. In 1519, a small town in Italy was experiencing a locust plague. The local bishop was so angry that his beard stood up when he saw the crops being eaten clean. But the bishop did not choose the traditional prayer to drive away the insects, but made a decision that stunned modern people. He wanted to solve this problem through legal means. So, an unprecedented locust trial kicked off. The court solemnly issued a formal summons to these six-legged suspects, requiring them to appear in court within a time limit to respond to the lawsuit. Imagine the scene. The court clerk sits upright, ready to record the defendant's defense. The judge wears a wig and holds a gavel, and the dock is empty. These arrogant locusts obviously do not take human judicial procedures seriously and continue to feast on the fields. Seeing the defendant's contempt for the court, the judges had to compromise. They marked out a special locust protection area and ordered the pests to move only in that area. The court also solemnly warned that if the locusts continue to do evil, they will face the serious consequences of church curse. This operation is like negotiating with robbers. Please only rob this street. Don't go anywhere else. It's really ridiculous. Even more absurd is the weevil trial in France in 1520. A group of weevils were sued by local farmers for eating grapevines. The court not only appointed defense lawyers for these insects, but also listened carefully to the arguments of both sides. The farmer's attorney passionately accused the weevils of atrocities, while the insect's defense lawyer argued that his client was just following the instinct given by God to survive. This human-insect war ended with the court ordering the weevils to move out within a time limit. As for whether these insects obeyed, only God knows. The most exciting of these insect trials was the caterpillar case in Switzerland in 1545. Local residents sued a group of caterpillars for destroying crops, and the court actually ruled that the caterpillars must leave the parish territory within 3 days. In order to ensure the execution of the judgment, the court also specially appointed a clergyman to read the judgment in the field. This operation is as naive as giving a tiger a restraining order and expecting it to walk into the cage by itself. So the question is, why were medieval people so obsessed with judging these insignificant little insects? The answer may be more interesting than you think. In that era when science and reason had not yet fully awakened, people believed that everything in the world was in God's order. Dealing with pest problems through formal judicial procedures is actually a special religious ritual, both a manifestation of God's authority and an alternative struggle against natural disasters. This way of thinking seems incredible to us today, but it was normal at the time. Just like modern people will restart their computers when they encounter technical failures, the first reaction of medieval people when they encounter insect plagues is, let's have a trial. It's just that they didn't restart the system, but the entire natural order. From the perspective of modern entomology, the biggest irony of these trials is that those insects accused of destroying crops are actually just doing what they have been doing for millions of years. Just like judges will not sue the sun for being too hot, these insect trials in the Middle Ages essentially reflect human misunderstanding and struggle against the laws of nature. When scientific explanations are absent, legal procedures become an alternative way for people to understand the world. Speaking of this, I can't help but think of the various strange lawsuits in modern society. Someone in the United States sued his neighbor's cactus because of poor Wi-Fi signals, and a company in Japan sued a programmer because of a software bug. Compared with their counterparts in the Middle Ages who sent subpoenas to insects, modern people at least don't have to worry that the defendant will eat their subpoenas as snacks. This similarity across time and space may just illustrate that when humans face uncontrollable factors, they always tend to use the tools they are most familiar with, such as the law, to seek solutions. Although these insect trials were absurd, they inadvertently promoted the budding of early environmental protection awareness. In some cases, judges would order some plants to be kept for insects to eat. The concept of this ecological reserve was a full 500 years earlier than the modern environmental movement. Ironically, humans eventually learned to live in harmony with nature by trying to set rules for nature. When we laugh at the ignorance of medieval people, perhaps we should also reflect: are we repeating the same mistakes in different ways today? Just like those judges who tried to control insects through legal procedures, modern people are also trying to tame nature with technological means, but the results are often counterproductive. This similarity across time and space may be the most valuable lesson left to us by history. At a deeper level, these insect trials reveal an eternal proposition. How do humans find their place in an uncontrollable world? Medieval people chose to use laws to frame nature, and modern people chose to use technology to transform nature, but both are essentially trying to establish order in chaos. It's just that the former used parchment and ink, while the latter used codes and algorithms. Speaking of this, let's turn our attention to the most special suspects in medieval courts, those animals who were believed to be possessed by demons. These cases pushed the absurdity to a new level, and even professional animal exorcists appeared. But this is another more bizarre story. In the gloomy courts of the Middle Ages, if the trial of ordinary animals is outrageous enough, then when the judges encounter animals possessed by demons, the entire judicial system is as crazy as collectively taking hallucinogenic mushrooms. Imagine this scene. A bull suddenly goes crazy and butts people, and the villagers don't think about how to subdue it, but instead hold an emergency meeting to discuss whether this guy is possessed by Lucifer. Thus, an exorcism drama that combines legal procedures, theological theories, and rural superstitions was staged, and its absurdity makes modern horror film writers feel ashamed. The most famous case is the Devil's Cock trial that took place in a small French town in 1565. A rooster was accused of colluding with the devil because it crowed on time at midnight for 3 consecutive days. The local priest swore that this was definitely Satan's demonstration to believers. The court specially formed a 3-in-1 jury consisting of judges, theologians, and veterinarians for this purpose. After all, to determine whether a poultry is possessed, it requires both legal knowledge and theology, and it is best to be able to see the symptoms of avian influenza. The trial scene can be called a masterpiece of magical realism. The clerk carefully recorded every crow of the rooster. The defense lawyer tried to prove that his client was just disordered biological clock, and the prosecution brought out the illusion of the devil incarnated as a snake in the Bible. In the end, the unfortunate rooster was found guilty, but considering that it might really be innocent, the court mercifully decided not to execute it, but ordered the priest to perform an exorcism ceremony on it. So people witnessed the most ridiculous exorcism scene in history. The priest held a cross and chanted a spell to a tied rooster, and the rooster looked back at him with a mentally retarded look. Even more outrageous than this was the demon sow case in Germany in 1582. A sow suddenly refused to eat the feed blessed by the church, but instead stepped on and gnawed a fallen Bible. The local bishop immediately announced that this was an obvious sign of possession and asked the court to punish it severely. The trial lasted for 2 weeks, during which more than 20 witnesses were summoned, including a peasant woman who claimed to see the sow's eyes turn red, and a drunkard who swore that he heard Latin coming from the pigsty. According to court records, the defense lawyer had made a brilliant argument. If it was really a demonic possession, then it was the demon that should be tried, not the pig. But the judges obviously did not intend to miss this opportunity to show off their divine power, and ultimately sentenced the sow to be burned alive. A universal solution for medieval people to deal with supernatural events, just like modern people restarting their computers when they encounter a computer crash. On the day of the execution, residents of the entire town came to watch, and the priests dressed in full robes recited exorcisms, while the poor pig's screams in the fire were interpreted as the sound of the demon is being purified. The most ridiculous of these cases is the demon cat class action lawsuit in Switzerland in 1604. A dozen cats in a village suddenly behaved abnormally, some dancing strangely on the roof of the church, and some staring at the holy images and crying like babies. The local religious court was in a state of emergency and immediately launched the anti-cat cult investigation procedure. Investigators used magnifying glasses to examine the pupils of each suspected cat, recorded the frequency of their calls, and even analyzed the shape of their feces. This may be the earliest animal criminal behavior profile in history. In the end, 7 cats were judged to be undoubtedly controlled by demons and sentenced to drowning. The execution process was full of ritual. Each cat was individually put into a cage covered with holy cloth, escorted to the river by 4 priests, and thrown into the water after reciting the Lord's Prayer 3 times. According to the theory at the time, if a cat floats, it proves that it is possessed by a demon, and if it sinks, it is innocent. In the end, all 7 cats sank. But the court explained that this was because the demon is too cunning and insisted on sentencing them guilty. This logic of they have to die no matter what is even more overbearing than the KPI assessment of some companies today. So the question is, why were people in the Middle Ages so obsessed with animals being possessed? The answer lies in the unique cognitive framework of that era. In an era when science and rationality were not yet popular, any abnormal phenomenon was attributed to supernatural forces. A cow suddenly went crazy? It must be the devil's doing. A hen laid deformed eggs? It must be a witch's curse. This mode of thinking is like a fully automatic blame-shifting system. Everything that cannot be explained is blamed on the devil. What's more ironic is that by judging these demon animals, the church not only demonstrated its authority but also diverted people's attention from real problems. When farmers were busy watching the exorcism ceremony, who would think about whether this year's taxes were too heavy? From the perspective of modern animal behavior, these so-called signs of possession actually have reasonable explanations. The crowing of a rooster in the middle of the night may be disturbed by the moonlight. The sow chewing the Bible may be because the book is stained with the smell of feed, and the abnormal behavior of a group of cats is likely to be collective food poisoning. But people at that time would rather believe that the gates of hell were opened than admit that they might have fed moldy feed. This tendency to mystify all abnormalities is as ridiculous as some people now attribute the lag of mobile phones to being hacked, when in fact it is just insufficient memory. The most absurd thing about these trials is that they forcibly grafted religious trials and animal behavior studies, producing a weird, divine animal law. Judges had to cite biblical provisions and consider the living habits of livestock. Defense lawyers had to talk about legal procedures on the one hand and understand exorcism rituals on the other. This mixed judicial system is like forcing a modern zoo, court, and church into one institution. Speaking of modern society, the ghosts of these demon animal trials are still floating around us. It's just that today's exorcists have been replaced by pet psychologists, and possession diagnosis has become animal behavior correction. But the human impulse to impose explanations on animal behavior has not diminished at all. When a popular cat is interpreted as a spirit because of a disgusted expression, we are only one step away from the peasants in the Middle Ages who believed that cats could cast spells. From a psychological perspective, these trials reflect the deep fear of human beings for losing control. When familiar animals suddenly behave abnormally, it is like a crack in the natural order, and trials and exorcisms are a psychological ritual to repair the order. Modern people frantically stock up when encountering an outbreak, which is essentially the same psychological mechanism as the medieval people burning demon pigs, regaining a sense of control through some kind of ritual behavior. These cases also accidentally promoted the development of early veterinary science. In order to determine whether animals are really possessed by evil spirits, some enlightened scholars began to systematically observe animal behavior and record pathological symptoms. This is like discovering the principles of chemistry by accident through alchemy. Humans have once again touched the door to science through absurd paths. When we laugh at the ignorance of the medieval people, perhaps we should touch our conscience. In today's information explosion, don't we often attribute unexplainable phenomena to alien technology or supernatural forces? Those short video bloggers who swear that pets can communicate with spirits and the peasant woman who identified the rooster as possessed in the past are essentially using the same brain circuit. The only difference is that they use mobile phone apps and algorithm recommendations instead of the Bible and burning. From a broader perspective, these demon-animal trials are actually the awkward adolescence in the process of human cognitive evolution. Just like teenagers seek self-identity through strange costumes, medieval society also established its own worldview through these absurd rituals. It's just that their way of makeup for the world is to burn a few animals, while we choose to stick rhinestones on our phones, different forms, but the same essence. Speaking of this, I can't help but think of the legal discussions on AI in some countries now. When we seriously debate should artificial intelligence have human rights, will future historians regard this as the animal trial of the 21st century? Just like the medieval judges entangled in whether the pig has free will when the devil is in the pig's body, we are also using limited cognitive frameworks to fit things that do not belong to this framework at all. This similarity across time and space may be the black humor of civilization development. The real legacy of these trials is to remind us of the limitations of our cognition. Those judges firmly believed that they were defending the sacred order, but in fact they were just performing a collective hallucination. This is just like some people now firmly believe that forwarding in a certain posture can bring good luck full of ritual sense. The effect depends entirely on imagination. The only difference is that they burned real pigs, and we forwarded virtual koi. When the last demon animal was vindicated at the dawn of the Enlightenment, humans finally began to learn to look at nature with a scientific rather than superstitious eye. But the value of this absurd history lies in its absurdity. Like a funhouse mirror, it reflects all the stumbling and funny things on the road of human rational growth. The next time your cat looks at you with a mentally retarded look, think about the animal predecessors who were tried. They used their lives to interpret a truth in the crazy world of humans. Being normal is the most abnormal. When these animals accused of demon possession turned to ashes on the stake, the medieval people's fanatical pursuit of the supernatural did not stop. In fact, their imagination has long gone beyond the animal kingdom and began to point the finger at more bizarre defendants, those everyday objects that are believed to have evil magic. Yes, you heard it right. In that crazy era, even a chair or a mirror could be brought to court and face serious charges of using black magic. Let's turn our attention to the most ridiculous type of trial in medieval courts in Europe, the trial of inanimate objects. This judicial practice shows the logical black hole of medieval people vividly. Since animals can be convicted, objects that harm people should certainly be subject to legal sanctions. So you will see the court sitting upright to judge a murderous chair, or solemnly announcing that a well has been permanently sealed for poisoning. This operation is like bringing the magic furniture in Beauty and the Beast to court, except that medieval judges are serious. The most famous case is the murderous wooden beam trial in Dijon, France in 1457. A beam that fell from the roof killed 3 workers, and the local court actually prosecuted the wood for manslaughter. The court appointed a defense lawyer for the beam. This unfortunate lawyer may be the first legal practitioner in history who had to defend a dumb object. During the trial, the prosecution detailed the criminal facts of the beam, while the defense lawyer tried to prove that his client just followed the law of gravity. In the end, the court sentenced the beam to exile. Yes, they really tied the wood to a carriage and transported it outside the city and held a formal exile ceremony. This kind of magic operation is as magical as modern people bringing a car that hits and kills people to court and then sentencing it to lifelong ban on the road. Even more outrageous is the magic mirror trial in Italy in 1499. A mirror was accused of premeditated murder because it reflected 3 owners to death in a row. Court records show that the mirror was locked in the dock and surrounded by sword-wielding guards, in case it suddenly cast a witchcraft. The local bishop personally testified in court, claiming to see the devil's reflection in the mirror. The most ironic thing is that the mirror was eventually convicted of a crime by letting it reflect a priest. The priest caught a cold the next day, and the court immediately declared this conclusive evidence of a crime. In the end, the murder mirror was smashed in public, and the fragments were buried at crossroads in different parishes to prevent it from lingering around. This way of handling is even more cautious than modern people's handling of nuclear waste. The most creative of these trials was the cursed bell case in Germany in 1523. The bell of a village church would automatically ring at midnight, and the villagers firmly believed that this was a precursor to a curse. The local court actually tried the bell for disturbing social order, and even found a metallurgical expert to test whether it had been tampered with. When the expert said that there was no problem with the bell, the judges became even more panicked. This meant that the curse might be true. In the end, the unfortunate bell was sentenced to exile, and the villagers raised funds to transport it to the wilderness hundreds of miles away and discard it. 3 months later, when another new bell had the same problem, they realized that the structure of the bell tower might have caused the resonance. But it was too late, and the evil bell had long since disappeared. So the question is, why did the irrational medieval people insist on judging these innocent objects? The answer may be more intriguing than imagined. In that era full of uncertainty, any accident was regarded as the intervention of supernatural forces. Sanctioning the offending objects through legal procedures is actually a psychological defense mechanism. It not only finds a scapegoat for the disaster, but also regains a sense of control through a sense of ritual. Just like modern people hit the floor 3 times after wrestling, but the medieval people upgraded this behavior to a full set of judicial procedures. From the perspective of modern physics, the most ironic thing about these trials is that they completely confuse natural laws with moral judgments. A fallen piece of wood is due to structural aging. A mirror killing a person may be caused by an infectious disease, and a bell automatically ringing is a mechanical failure. But in the eyes of medieval people, these are all manifestations of free will. This way of thinking is as absurd as taking Newton's laws as moral codes. Speaking of modern society, this kind of animism trial thinking has never really disappeared. When an autonomous car has an accident, people's first reaction is to hold the car responsible. When an AI chatbot makes inappropriate remarks, the developer's first reaction is to punish the algorithm. While we laugh at the medieval people's trial of wooden beams, we are also using the same logic to treat smart devices. The only difference is that we don't use burning and exile, but system reset and algorithm correction. These cases also accidentally promoted the development of early materials science. In order to determine whether there is a problem with the magic mirror, the court had to study the glass manufacturing process. In order to find out the truth about the cursed bell, people began to pay attention to the principles of acoustics. Just like finding out chemical knowledge through alchemy, humans once again approached the scientific truth by accident through the most absurd path. When we laugh at these trials from a modern perspective, perhaps we should think, if the medieval people saw us setting the 3 laws of robotics for AI, or applying for patents for cloned sheep, would they also think that we were conducting some kind of high-tech version of object trial? This similarity across time and space is the most bitter irony in the development of civilization. From a deeper level, these trials reveal a universal law of human cognitive development. When faced with the unknown, we always use a familiar framework to understand it first, even if this framework is extremely absurd. The medieval people used legal trials to explain physical phenomena, just as modern people use the information age to analogize the operation of the brain, which are all inevitable products of the cognitive transition period. Speaking of this, I can't help but think of the current regulatory discussions on blockchain technology in some countries. Are we also using the legal framework of the industrial age to judge the products of the digital age? Just like the medieval people used religious trials to deal with mechanical failures, this misplaced sense of absurdity may become another joke in history books 500 years later. The real revelation left by these object trials is that when humans encounter incomprehensible phenomena, the first thing to start is not reason, but imagination. And history has proved that from imagination to reason, it often takes a long trial and error road full of laughter and tears. Just like the wooden beams and bronze bells that were judged, they innocently became stepping stones on the road of human cognitive evolution, silently witnessing how humans step by step from superstition to science, from absurdity to rationality. In the absurd trial farces in medieval Europe, if the trial of animals and objects is outrageous enough, then when the human judicial system encounters supernatural crimes, the whole story begins to run wild in the direction of magical realism. Imagine this scene. A group of judges wearing judicial hats, sitting upright to try a ghost theft case, or seriously discussing whether a vampire should be deprived of citizenship. This is not the plot of a fantasy novel, but a real judicial anecdote that happened in medieval Europe, in that era when the boundaries between science and superstition were blurred. Even ghosts had to abide by human court procedures. The most ridiculous case is the ghost libel case in France in 1429. After a farmer named Richard died, his ghost frequently appeared in the village, telling everyone that his friend Pierre had stolen his money. This matter caused a lot of trouble in the city, and Pierre was so annoyed that he took Richard's ghost to court in anger. Yes, a living person suing a dead person. This operation would make even the most experienced lawyers doubt their lives today. The court actually accepted the case and summoned the defendant to appear in court in a serious manner. When the ghost certainly could not show up, the judge announced that the ghost would be tried in absentia for contempt of court. The final judgment required Richard's ghost to stop the libel immediately, otherwise he would face soul exile. The specific operation was to dig his remains out of the church cemetery and throw them into the wilderness. The most ironic ending of this farce is, when people really dug up Richard's grave, they found that there was indeed a sum of money missing from his pocket, and Pierre mysteriously disappeared the next day. It seems that sometimes even ghosts are closer to the truth than courts. Even more absurd is the vampire property dispute case in Germany in 1487. A nobleman who had been dead for 5 years suddenly resurrected and began to visit his castle at night to ask for his inheritance. His nephews were terrified and quickly took this vampire uncle to court, demanding that his legal death status be declared valid. This trial can be called performance art in judicial history. The court summoned more than 20 witnesses, including a shepherdess who claimed to have been sucked of blood, and a blacksmith who swore that he saw a vampire counting gold coins in the moonlight. The defense lawyer, yes, they even found a lawyer for the vampire, put forward a genius argument. Since my client can walk and talk, he is not considered dead in law. The judges argued about this for a full 3 months and finally compromised. The vampire can retain his citizenship, but must sign a guarantee to promise not to scare the villagers again and give up the right to manage the daytime property. The funniest part of this case is that the verdict specifically states that this ruling applies only to vampires in this case and does not constitute a precedent for other supernatural creatures, for fear that groups of zombies will come to sue in the future. The most imaginative judicial case among these cases is the werewolf murder case in Italy in 1540. A woodcutter named Giovanni was accused of transforming into a werewolf and biting his neighbor to death on a full moon night. The court evidence included: witnesses claimed to have seen him grow a tail, doctors testified that his teeth were abnormally sharp, and priests swore that suspicious fur was found in his home. But the most amazing thing is the defense strategy. Giovanni's lawyer did not deny that the client was a werewolf, but insisted that he was not criminally responsible during the transformation. This defense angle is so unique that it is comparable to modern lawyers using sleepwalking state to exonerate murderers. The court finally accepted this statement and ruled that Giovanni was not guilty in the human state, but required him to lock himself in the cellar every full moon. This may be the first supernatural creature control regulation in history. Then the question is, why did the medieval judicial system take these supernatural cases so seriously? The answer may be more ironic than you might imagine. In that era of plague and war, people were in urgent need of establishing order in chaos. Dealing with supernatural events through legal procedures is actually a different kind of psychological comfort. If even ghosts have to abide by human rules, then the world is still controllable after all. This mentality is like modern people frantically forwarding coy when they encounter a crisis. They are all instinctive reactions when facing the unknown. From a modern scientific perspective, the most ridiculous thing about these cases is that they forcibly graft natural phenomena with supernatural explanations. The so-called vampire is likely to be a poor person with porphyria, the werewolf may just be a patient with hypertrichosis, and the haunting is mostly a collective hallucination or a strange sound caused by the building structure. But in an era when even bacteria are not known, these explanations are less convincing than the devil is haunting. Just like explaining Wi-Fi signals to medieval people, they would rather believe that angels are transmitting information. When it comes to modern society, this kind of legal omnipotence thinking has never disappeared. When AI starts to create art, we rush to discuss copyright ownership. When disputes arise in blockchain, the court insists on using traditional property law to make a ruling. While we laugh at the medieval people for using laws to frame ghosts, we are also using the legal framework of the industrial age to constrain the products of the digital age. This absurd sense of time and space dislocation is no less than issuing a ticket to a vampire. These supernatural trials also accidentally promoted the development of early forensic medicine. In order to determine whether a person is really resurrected from the dead, judges have to study the laws of corpse decay. In order to find out the authenticity of werewolf, doctors began to systematically record cases of excessive hair growth. Just like the accidental discovery of chemical principles through alchemy, humans have once again accumulated scientific knowledge through the most absurd path. When we laugh at these cases from a modern perspective, perhaps we should think, if the medieval people saw us using metaverse regulations to manage the virtual world or set personality rights for AI, would they also think that we are playing some kind of high-tech version of ghost hunting? This similarity across time and space is the most bitter irony in the development of civilization. Humans always use old tools to deal with new problems until they are slapped in the face by reality. From a deeper level, these trials reveal the essential limitations of the legal system. It always lags behind the forefront of human cognition. The medieval people used feudal law to judge supernatural phenomena, just like modern people use copyright law to restrict AI creation. They are all inevitable products of the cognitive transition period. The only difference is that they are facing imaginary ghosts, and we are facing real digital ghosts. Speaking of this, I can't help but think of the legislative discussions on quantum computing in some countries now. Are we also using the thinking of the classical physics era to regulate the products of the quantum world? Just like the medieval people used the Inquisition to judge vampires, this absurd sense of dimensional mismatch may become another cold joke in the textbooks 500 years later. The real legacy left by these supernatural trials is to remind us of cognitive humility. Those judges firmly believe that they are upholding the dignity of the law, but in fact they are just performing a collective self-entertainment. This is like some internet celebrity lawyer's long speeches on the property rights of the metaverse, now full of posture, but maybe completely off track. The only difference is that they burn witches and we block illegal accounts. When the last supernatural defendant was vindicated in the dawn of the scientific revolution, humans finally began to learn to distinguish between facts and fantasies. But the value of this absurd history lies in its absurdity, like a magic mirror, reflecting all the stumbling and funny things on the road of human rational growth. The next time you hear that a certain country's parliament is discussing the AI human rights bill, think about the vampire predecessors who were tried. In the face of human crazy legal imagination, even supernatural creatures seem so normal. When the judges in medieval Europe finally realized that even ghosts and vampires could not escape their trial, the appetite of this group of legal maniacs became bigger and bigger. So, the most absurd chapter in judicial history began. They began to judge things that did not exist at all. That's right, in that crazy era, even abstract concepts could become defendants. From the bad air that spread the plague to the evil thoughts that tempted people to commit crimes, no one could escape the hammer of justice of the medieval court. This operation is as magical as giving a speeding ticket to a rainbow or convicting a dark cloud of illegal rainfall. Let's turn our attention to Marseille in 1348, where an unprecedented judicial farce was being staged. When the Black Death was raging, desperate citizens decided to sue miasma, the poisonous air they believed spread the plague. The court solemnly opened an investigation and summoned dozens of witnesses to testify, including an old woman who claimed to have seen black mist wrapped around the patient, and a priest who swore that he smelled the stench of sulfur. The most amazing part was the defense, because miasma could not defend itself. The court actually appointed a philosopher as a friend of the court to speak on behalf of this abstract concept. The unfortunate scholar stammered and quoted scriptures, trying to prove that his client just followed the flow of natural laws. In the end, the court found the miasma guilty and ordered the whole city to light incense to purify the air. It also stipulated that anyone who created miasma, such as not taking a bath, would be sentenced to flogging. The most ironic thing about this case was that the judge who presided over the trial fell ill and died 3 days after the verdict came into effect. It seemed that the miasma had no respect for judicial authority. Even more outrageous than this is the evil thought case in England in 1402. A thief named Tom made a surprising defense in court. He didn't want to steal, but the criminal thought controlled him. Instead of throwing out this lame excuse, the judges solemnly decided to try this criminal thought separately. So the most abstract trial in judicial history began. The court clerk carefully recorded the accusation of a mental activity. The jury seriously discussed how to punish a non-existent entity, and the accused thief sat in the audience and watched his excuse become the main show. The final verdict required Tom to confess to expel the evil thoughts and declared the criminal thought to be a concept not protected by law. This is equivalent to a modern court declaring an emoji expression illegal. The funniest sequel to this farce is that 3 months later, Tom was arrested for stealing again. This time he argued that it was another new thought that did it, and the judge really opened another trial of criminal thought too. The most philosophical of these cases is the hate trial in Italy in 1486. The two families had a blood feud for generations, and the newly appointed judge had a wild idea and decided not to judge specific people, but to directly judge hatred itself. The court summoned psychologists, called soul doctors at the time, poets, and even mathematicians to try to define this abstract emotion. The debate lasted for a whole month, during which there were absurd scenes such as poets and theologians fighting each other and mathematicians trying to use equations to prove the volume of hatred. The final verdict can be called performance art, declaring hatred an illegal emotion, ordering the two families to hug in public in the square, and stipulating that anyone who feels hatred in the future must immediately buy indulgences. This may be the first emotional tax in history. Of course, the effect of this verdict is like using paper cups to hold lava. The two families continued to fight after leaving the court, but the judge was satisfied to leave his own brain hole in the history of justice. So the question is, why did the medieval people who lacked rationality insist on judging abstract concepts? The answer lies in the unique cosmology of that era. In their eyes, the world is ruled by God's will rather than natural laws, so all misfortunes can be attributed to some kind of moral error. Judging abstract concepts is like modern people restarting their computers, an attempt to reset the system, except that they are restarting the moral order of the entire universe. From the perspective of modern cognitive science, the most ironic thing about these trials is that they perfectly demonstrate how humans treat psychological projections as objective reality. Miasma is essentially an ignorant fear of microorganisms. Criminal thoughts are confusion about free will, and hatred is a scapegoat for group conflicts. Medieval people externalized these inner anxieties into objects that can be judged, just as naively as a child blaming the floor for falling down. The only difference is that children can only stamp their feet at most, while medieval judges will go through the entire judicial process. Speaking of modern society, this judgment abstract thinking mode is actually lingering. When internet companies develop hate speech recognition algorithms, or parliament legislates to ban bad ideas, we are only a technological generation behind medieval judges. They write judgments in Latin and we write code in Python, but the arrogance of trying to frame human nature with rules is exactly the same. These absurd trials unexpectedly gave birth to the embryonic form of early psychology. In order to define criminal thoughts, scholars began to systematically study human motivations. In order to analyze hatred, philosophers had to distinguish between emotions and behaviors. Just as alchemy accidentally promoted the development of chemistry, these judicial farces also inadvertently sowed the seeds for science. When we laugh at the ignorance of the medieval people, perhaps we should look in the mirror. In modern society, don't we often anthropomorphize market panic or demonize systemic risk? The only difference is that we don't use Latin spells and exorcism rituals, but economic models and monetary policies. The tools are advanced, but the inertia of thinking remains. From a broader perspective, these trials reveal the deep dilemma of human cognition. We always create concepts first, and then are backfired by the concepts. The medieval people invented miasma to explain diseases, and then they were scared by their own inventions and judged the air. Modern people created the concept of metaverse and are now trying to legislate for it. This kind of comedy of self-destruction has been repeated in the history of civilization. At this point, I can't help but think of the current ethical discussion on artificial intelligence. Are we also repeating the absurdity of judging criminal thoughts? When experts seriously debate whether AI has malicious intent, it is very similar to the medieval judges' struggle over whether evil thoughts exist independently. This echo across time and space may be the most humorous footnote to human nature. The real legacy left by these abstract trials is to remind us of the limitations of cognition. Those judges firmly believed that they were purifying the world, but in fact they were just playing word games. Just like modern social media uses sensitive word filtering to create a false sense of harmony, they are all self-deceptions that only treat the symptoms but not the root cause. The difference is that they use parchment and the stake, and we use algorithms and account bans. When the last abstract defendant was released during the Enlightenment, humans finally began to face the complexity of reality. But the value of this absurd history lies in its absurdity. Like a funhouse mirror, it reflects all the arrogance and fragility of humans when facing the unknown. Next time you hear that a country has enacted a law to ban bad algorithms, think about the evil ideas that have been tried. In the face of human obsession with trying to regulate everything, even ethereal concepts cannot escape the law. After the absurd farces of trying abstract concepts in the Middle Ages in Europe, human judicial imagination seems to have reached a certain peak of madness. But just when you think that trying the air is the limit of human imagination, history has brought us an even more incredible dish, the trial of corpses. That's right. In that magical era, the dead not only had to be responsible for their actions during their lifetime, but also had to crawl out of the grave, of course only symbolically, to accept the court's verdict. This operation is as jaw-dropping as giving a mummy a traffic ticket or sentencing a dinosaur for vandalism. Let's freeze the time in January 897. When the Lateran Palace in Rome was performing a judicial spectacle that was enough to make modern jurists collectively collapse. Pope Stephen VI ordered the body of former Pope Formosus to be dug up, dressed in full papal robes, and then put on trial. This farce, known as the Cadaver Synod, is the darkest comedy in judicial history. The court solemnly appointed a defense lawyer for the corpse that had been rotting for 9 months. The unfortunate priest may be the first legal practitioner in history to have to defend a corpse, and his client not only could not speak, but also continued to emit a stench. During the trial, the attendants had to hold the corpse's arms from time to time to make responses, like performing a horror puppet show. In the end, the court found the corpse guilty, declared all its religious appointments invalid, then cut off the 3 fingers it used to bless, and threw the remains into the Tiber River. But the most ironic twist in this story is that a few months later, the people revolted and Stephen VI himself was overthrown. The new pope not only declared the zombie trial invalid, but also thoughtfully fished out the remains of Formosus and reburied them. This may be the first judicial overturn and corpse recovery case in history. Even more blackly humorous than this is the suicide trial in France in the 14th century. The Christian doctrine at that time believed that suicide was a felony, so courts in various places began to prosecute the bodies of suicides. In 1313, a businessman named Pierre hanged himself because of debt. The local court actually dug his body out of the grave and formally prosecuted him for suicide. The trial process can be called performance art. The body was tied to the dock, with a novice monk serving as the corpse spokesman, and the judges seriously discussed how to punish someone who has punished himself. The final verdict declared Pierre's soul guilty, ordered his body to be paraded through the streets, and then dumped in a garbage dump, and confiscated all his property. This is equivalent to the modern court ruling that you will be fined even if you die. The funniest part of this farce is that Pierre's creditors actually lined up to collect the compensation, completely unaware that they were participating in the most morbid debt settlement in history. The most creative of these corpse trials was the treasonous skeleton case of the Holy Roman Empire in the 15th century. A nobleman who had died many years ago was revealed to have committed treason, and the court actually decided to try his remains. Since the body had turned into bones, the judges ingeniously dressed the skeleton in his lifetime clothes, stuffed cotton in the eye sockets to simulate eyes, and stuffed a mechanical device into the jawbone so that it could speak. This may be the first judicial horror doll in history. The trial lasted for a full 7 days, during which the defendant's wig fell off 3 times. The mandible fell off 5 times. And on the last day, a wild dog even broke in and took away a rib of the defendant. But the judges were not affected at all, and still solemnly sentenced the skeleton to treason, and ordered it to be hung on the city wall for public display. The absurdity of this case is comparable to modern people using ChatGPT to generate testimony and then suing a printer. So the question is, why was the medieval judicial system so obsessed with corpses? The answer may be more morbid than imagined. In that era without modern forensic medicine, death was not the end of responsibility, but the beginning of another legal relationship. By judging corpses, living people can both demonstrate power and obtain some twisted psychological satisfaction. Just like modern keyboard warriors brushing "you deserve it" under the news of dead people, except that the medieval people upgraded this behavior to a full set of judicial procedures. From the perspective of modern justice, the most ironic thing about these trials is that they perfectly illustrate what form is greater than substance means. The judges knew that the corpses could not speak, resist, or escape from prison, but they still insisted on going through the entire trial process, as if those Latin spells and parchment could really hurt the dead. This self-deceiving sense of ritual is as ridiculous as some modern companies holding review meetings to blame colleagues who have left. Speaking of modern society, this kind of dead people take the blame thinking has never disappeared. When we prosecute deceased pilots after an air crash, or hold deceased economists accountable during a financial crisis, we are only a technological generation behind the medieval judges who tried corpses. They punished the dead with the gallows, and we whipped corpses in the court of public opinion. In essence, both are cowardly manifestations of not daring to face systemic problems. These corpse trials unexpectedly promoted the development of early forensic medicine. In order to determine whether a death was really suicide, judges had to study corpse phenomena. In order to confirm whether the nobles were really treasonous, anatomy began to be used for evidence collection. Just like the accidental discovery of chemical principles through alchemy, humans once again accumulated scientific knowledge through the most morbid path. When we laugh at the ignorance of the medieval people, perhaps we should look in the mirror. Don't we often see belated trials of deceased celebrities on modern social media? The only difference is that we don't use Latin verdicts and gallows, but hot search topics and keyboard warriors. The tools are civilized, but the witch-hunting mentality remains. From a deeper perspective, these trials reveal the deep fear of death in human beings. Punishing corpses through judicial procedures is actually a deformed way for living people to fight against death anxiety. If even the dead are subject to trial, then death may not be the end. This mentality is like a child believing that dolls will hurt, which is a naive stage that must be passed in cognitive development. Speaking of this, one can't help but think of the judicial rehabilitation of historical figures in some countries today. Are we also repeating the absurdity of overturning the case and recovering the corpse in the Middle Ages? When a modern court declares a politician not guilty decades ago, it is very similar to the medieval pope's restoration of the reputation of the corpse. This echo across time and space may be the most bitter irony of judicial drama. The real legacy left by these corpse trials is to remind us of the limitations of the judiciary. Those judges firmly believe that they are upholding justice, but in fact they are just performing power rituals. Just like some modern truth investigation committees, they are all political shows performed by living people for living people. The difference is that they use real corpses, and we use symbolic historical ghosts. When the last judicial corpse was laid to rest in the dawn of the Enlightenment, humans finally began to understand the finality of death. But the value of this absurd history lies in its absurdity. Like a corpse mirror, it reflects all the fear and hypocrisy of human beings in the face of death. The next time you see a government redressing an injustice hundreds of years ago, think about the bodies of the popes who were tried. In the eternal pursuit of justice by humans, even death is not the end point. When judges in medieval Europe did not even let go of corpses, they had obviously taken the belief of judicial omnipotence to the extreme. But just when you think this is the ceiling of human judicial imagination, there is an even more ridiculous Easter egg hidden in the historical archives: the trial of natural disasters. Yes, in that crazy era, even earthquakes, floods, and locust plagues were taken to the dock and solemnly tried by human courts. This operation is like issuing a speeding ticket to a typhoon or sentencing a volcano to illegal emissions, which fully demonstrates the arrogance and naivety of human beings. Let's turn our attention to the French town of St. Julien in 1518, where the most ridiculous river trial in history was taking place. The local residents were angry because they had suffered from floods for many years and decided to sue this evil river. The court not only accepted the case, but also solemnly issued a subpoena to the river. The priest stood by the river and read it loudly, fearing that the river could not understand Latin. During the trial, the prosecution listed the crimes of the river in detail: destroying farmland, flooding houses, and causing the death of livestock. While the defense lawyer, they even found a lawyer for the river, argued that his client was just flowing in accordance with the laws of nature. In the end, the court ruled that the river was guilty of endangering public safety and ordered the local church to carry out an expulsion ceremony on it and erect a cross on the riverbank as a permanent ban. The most ironic follow-up to this case is that the flood came even more fiercely the following year and directly washed away the cross erected by the court. It seems that nature simply disdains the verdict of mankind. Even more outrageous than this is the earthquake trial in Italy in 1596. After an earthquake destroyed half of the town, angry residents decided to sue the natural phenomenon of earthquake. Since no specific defendant could be found, the judges creatively declared earthquake a fugitive criminal and issued a European wanted order. This is equivalent to the modern police's wanted order for gravity or electromagnetic waves. The court also ordered the residents of the town to participate in an exorcism ceremony once a week to prevent the earthquake demon from attacking again. This farce lasted for 2 full years until the new bishop couldn't stand it anymore and euphemistically pointed out that maybe we should strengthen the house instead of cursing the earth's crust. But the most hilarious thing is that local archives show that until the 18th century, the town still held a symbolic trial on the anniversary of the earthquake every year, like a judicial cosplay that lasted for 200 years. The most creative of these natural disaster trials was the hail claim case in Germany in the 16th century. After a sudden hailstorm destroyed the vineyards, the wine growers jointly sued the hail for compensation. The court not only accepted the case, but also required the plaintiff to provide hail samples as physical evidence. So you will see the funny scene of bailiffs collecting hail in the fields with jars. Since the defendant obviously would not appear in court, the judge creatively ruled: since the hail has melted and cannot be held accountable, the church, the representative of God, will compensate for the losses. This ruling set a precedent for using religious funds to compensate for natural disasters, resulting in farmers queuing up to go to the church to ask for money every time hail fell, just like the insurance claim seen in the Middle Ages. So the question is, why did the rational medieval people insist on judging natural disasters? The answer may be more sad than you think. In the era when science had not yet been enlightened, this seemingly absurd behavior was actually the only psychological defense mechanism for vulnerable groups in the face of disasters. Punishing natural disasters through legal procedures, just like primitive tribes praying for rain with dance, is the last way for humans to maintain their dignity when they are unable to change reality. From the perspective of modern earth science, the most ironic thing about these trials is that they completely anthropomorphize geological movements and meteorological phenomena. Rivers overflow because of excessive rainfall, earthquakes are normal plate activity, and hail is the product of atmospheric convection. But in an era when people don't even know about gravity, these explanations are more difficult to accept than God is angry. Just like explaining global warming to medieval people, they would rather believe that giants are cooking in the clouds. When it comes to modern society, this judgment of nature thinking mode is actually still lingering. When officials are busy looking for responsible people after floods, or when the media ask who is responsible after volcanic eruptions, the only difference between us and the judges who judged rivers in the Middle Ages is scientific literacy. They use exorcism rituals to fight disasters, and we use emergency plans, but the arrogance of trying to frame natural laws with human rules is exactly the same. These absurd trials unexpectedly promoted the germination of the early insurance industry. The Disaster Compensation Fund, established by the church to quell public anger, later evolved into the prototype of modern insurance. The practice of farmers jointly suing natural disasters gave birth to the concept of mutual insurance. Just like the accidental discovery of chemical principles through alchemy, humans have once again entered a new stage of civilization through the most stupid path. When we laugh at the ignorance of the medieval people, perhaps we should reflect. In today's climate change intensification, don't we often hear the argument of suing oil companies for causing typhoons? The only difference is that we don't use Latin spells and exorcism rituals, but carbon emission data and climate models. The tools are advanced, but the mindset of wanting to find the responsible party for all disasters has not changed at all. From a deeper level, these trials reveal the eternal dilemma of human cognition. We always create an explanatory framework first, and then are bound by the framework. The medieval people invented God's punishment to explain disasters, and then they were forced to judge rivers by their own inventions. Modern people created the concept of Anthropocene, and are now anxious to take responsibility for the entire geological era. This kind of comedy of self-destruction has been repeated in the history of civilization. Speaking of this, I can't help but think of the current panic about artificial intelligence. Are we also repeating the absurdity of judging earthquakes? When experts seriously discuss how to judge out-of-control algorithms, it is very similar to the medieval judges struggling with how to punish melting hail. This kind of thinking echo across time and space may be the most humorous footnote to human nature. The real legacy left by these natural disaster trials is to remind us of cognitive humility. Those judges firmly believe that they are upholding justice, but in fact they are just performing a collective psychotherapy. Just like modern people alleviate climate anxiety through environmental protection actions, they are all self-comfort in the face of great power. The difference is that they use religious trials and we use carbon credits. When the last natural disaster defendant was released in the scientific revolution, humans finally began to face the complexity of reality. But the value of this absurd history lies in its absurdity. Like a funhouse mirror, it reflects all the arrogance and fragility of human beings in the face of nature. The next time you hear that a government is going to sue climate change, think about the rivers that were tried. In the face of human obsession with trying to control everything, even the movement of the Earth's crust is forced to accept legal sanctions. Looking back at the absurd trial farces in the Middle Ages, from the hanged sow to the sentenced river, from the exorcist rooster to the wanted earthquake, we seem to be watching a judicial cosplay that lasted for hundreds of years. On the surface, these stories are a ridiculous imitation of justice by humans, but in essence they expose an eternal truth. When cognition encounters a bottleneck, humans would rather invent a set of absurd rules than admit their ignorance. Just as modern people would rather use constellations to explain personality than face complex psychological principles, medieval people used trials to label everything beyond their understanding, except that their labels were made of parchment and stamped with church wax. The most ironic thing about these trials is that the more serious they are, the more ridiculous they seem. Judges wearing robes discussed the criminal responsibility of sows. Bishops cursed a river that didn't understand human language in Latin, and lawyers defended the innocence of the melted hail. This absurd sense of disharmony is like a group of ants discussing how to legislate for humans. But from another perspective, isn't this a true portrayal of human beings facing the vast universe? We are still using the rules we invented to explain dark matter, define love with mathematical models, and constrain AI with legal provisions. In essence, it is no different from the medieval trial of natural disasters, except that the tools have changed from crosses to supercomputers. So the question is, how will humans 500 years later view our enthusiasm for legislating the metaverse today? Will they think it is stupid for humans in the 21st century to try to constrain AI creation with copyright law, just as we laughed at the zombie trial in the Middle Ages? When future archaeologists dig out our hard drives and find the ChatGPT terms of use stored in them, will they laugh so hard that they spray virtual coffee on the holographic projection? The real revelation left to us by these historical farces may be that humans are always measuring the infinite universe with their own cognitive rulers, and the jokes are generated in the gap between the rulers and reality. When we judge animals, we expose our ignorance of biological instincts. When we judge corpses, we show our fear of death. When we judge rivers, we show our powerlessness against natural forces. The absurdity of every era is a projection of cognitive limitations. Just as a flashlight cannot illuminate its own shape, it is difficult for humans to see the outline of their own ignorance. So, dear readers, next time you hear that a country has legislated to manage AI emotions or a company pays its algorithms, don't rush to laugh. This may very well be the 21st century zombie trial in future textbooks. Now it's your turn. What practices do you think modern society will make humans laugh out loud 500 years later? Is it taxing robots? Or preparing a human rights bill for aliens? Leave your thoughts in the comments section, like and repost this Human Confusion Behavior Award, and let's save more jokes for future archaeologists. After all, if even the sows on trial can be recorded in history, why can't your amazing comments?